right, Mr. Zanon? Can you hear me all right?
Yes, ma'am.
All right, People versus John Michael Zanon, 22-6940 SM. Mr. Zanon is present in court via Zoom from the Dickinson County Jail. His attorney is Robert Percola, who is present here in the courtroom. We are set for a bond, the prosecution appears through Prosecutor Lisa Richards. We're here for a bond violation hearing. I know you were just recently assigned, Mr. Percola. Are you ready to proceed today?
I don't believe that I've had an adequate amount of time to gather information related to this case. I have received the police report, but I have not received video and other evidence or had a chance to review it at this point. Second of all, Mr. Zanon has been cited for at least 2 civil infractions arising out of this matter that it's his intention to request formal hearings on, and we'll be following up with that shortly. Since those contested matters are arising out of the same facts and circumstances here, I think that could potentially be an additional reason to adjourn the bond violation to a later time. So that would be our request, Your Honor, along with a request to reconsider bond and establish a bail amount for Mr. Zanon to be able to pay to be released from jail.
All right, then. We have his companion bond violation hearing set on September 7th. I'm assuming that's your regular date. Are you on that one or not?
Yes, I'm representing him on that one as well, so that date would work for me should the court choose to use that one.
So is he willing to waive time?
Well, that's why I wanted the court to address his bond, Your Honor. I don't know if there are any time restrictions on it necessarily if he's out of jail.
Well, I had a conversation with Mr. Zanon back on the day that he came here initially, when I told him very simply and cleanly, the only reason, as I told all of his co-defendants, if they violated the terms of their bond, they would be sitting in jail pending. Mr. Zanon that day came in for a bond violation as well. I did not send him to jail, even though he had a bond violation in the interim time, because I told him I had not given him adequate notice, and I would consider any future bond violations reason to sit him in the jail pending trial. Now he's back again with another type of bond violation, more alcohol. The underlying charges are very serious, and I am not inclined to amend bond. In fact, I'm going to move the trial date up so we have it within 28 days. It was presently set for, I believe, October, given the fact that he was not in custody at the time that the trial date was set, October 7th. I have 2 days open. I'm going to set it for September 12th and 13th. We'll have a jury trial within the time frames. So the request to amend the bond is denied. As to the request on the bond violation, then what's your position, Mr. Percola?
Well, we would ask that it, at least a little bit of time to it. So I guess I would ask that it be scheduled for
Do you want it for September 7th, or do you want it for...
Well, I think, yeah, September 7th would work at the moment, I think, Your Honor.
The earliest date I could do it is the 31st, if that's a date available to you, if you would rather do it then, but...
Or, I did have more to add on the request for bond, but if I could just make the request that I meant to.
You may.
Thank you, Your Honor. I certainly understand the sentiment behind the court's warning of these defendants not to violate any terms and conditions of their bond, and that certainly the court would consider a lodge only when that or if that eventuality arose. However, I think when an issue like this does come up, I think looking at the particular circumstances is helpful, and I would ask the court to give some strong consideration to the circumstances here though Mr. Zanon has, this is a second alleged bond violation, the common denominator in each of them appears to be alcohol. He's a young man, doesn't have any prior criminal history beyond this. It would be my request that the court give some consideration to allowing bond in a misdemeanor matter like this, pending trial that is going to be a complex trial. It's my understanding that the prosecution is likely to be asking for a consolidation of trial for the number of defendants that are involved here, which would make Mr. Zanon's trial being moved up to a closer time difficult, not only for Mr. Zanon, but for the prosecution as well. I've discussed that with Ms. Richards and somewhat anticipating her comments on that. However, I think given the allegations here, and again, that common denominator of alcohol, that being released on a sober-link device would be more appropriate and would be an effective bellwether of Mr. Zanon following the rules while out on bond in the manner in which he's perhaps had some difficulty up to this point. I did check with the probation department prior to today's hearing. They do have a sober-link device available at this time. And my understanding, typically under the court rule for pretrial release, I don't believe this is the type of situation that a person being lodged pending trial would be appropriate. I just don't think it has the same features in terms of Mr. Zanon's potential being public that I think would otherwise justify it. So with all of those things in mind, I would ask the court to give some consideration to it. And I know my discussions with Mrs. Richards that she concurs to some extent at least in the request for sober if the court were to find it appropriate to grant him bail.
Ms. Richards?
Your Honor, if I could just make a record on a couple of points. First of all, I believe we were given approximately 2 business days to prepare for today's hearing. Mr. Zanon has been alleged to have consumed alcohol. However, the PBT reading was very low, so that we did request a subsequent test once he got to the jail. He was screened for drugs and alcohol. That was positive for alcohol. As far as I know, that is the only substance it was positive for. That was sent out to the laboratory for confirmation. I don't have those results back yet, and I don't anticipate having them back for approximately 2 to 3 weeks. So we aren't in a position today to really put on complete evidence with regard to the bond violation. I can certainly start it and have the trooper testify, but my guess is that the court would want to wait for the verification results to come back. Secondly, Your Honor, I can find no time requirement for a bond violation hearing in the court rule, unlike the rule applicable to probation violations that typically sets forth that the hearing must be held for 14 days. The rule I can find pertaining to a bond violation is a statute that's 4.15e, and it just indicates that the court shall give priority to cases brought under the section in which the defendant is in custody. So I don't believe that the court is operating under a specific time timeline with regard to the holding of the bond violation hearing.
All right, thank you, Ms. Richards.
There was another point of,
Yes, please.
Your Honor, the prosecution does anticipate filing a motion to consolidate the however many defendants are left that wish to have a trial. Would be my intention to file a motion to consolidate those remaining defendants for purposes of trial. So I do anticipate that, given everyone's schedule, I think under the rules that the rules certainly favor consolidation, and I believe that the court would likely grant it. And getting everyone's schedules to provide for a trial within the near future would probably be near impossible. So I wouldn't anticipate a trial before first of the year if the court grants the motion for consolidation. However, I think that delay, the delay that results from the bond violation is attributable to the defendant, not to the prosecution. So, having said all that, Your Honor, I would leave within the court's discretion the decision of whether or not a sober link would adequately protect the public. I think Mr. Zanon has proven that prior pretrial conditions have not been sufficient to safeguard the public. Whether a sober link could achieve that, I would say it is arguable.
I'm going to take a break. I'll be back.
All rise.